You've seen it. I mean, we've all seen it. You're walking through a used car lot, maybe kicking the tires on a sedan that's seen better days. Or maybe you're scrolling through Zillow late at night, looking at a fixer-upper that seems just a little too cheap to be true. And there it is.
That little sticker.
That sticker in the window or a bolded line in the contract. Just 2 little words. As is.
It looks so harmless, doesn't it? Just 2 syllables. It feels almost casual, you know?
That does. It feels colloquial. Like,
Yeah.
hey, what you see is what you get. It seems simple.
Yeah.
But the reason we're doing this deep dive today is because those 2 words are actually some of the most dangerous, heavy-lifting vocabulary in the entire business world.
Oh, absolutely. It's a deceptively simple phrase.
Because when you sign next to as is, you aren't just agreeing to the condition of the item. You're stepping into a legal minefield. So, welcome to the deep dive. Today, we are unpacking the legal DNA of the as-is clause.
We're going to look at why it exists, how it effectively strips you of your rights, and the very narrow, very specific loopholes that might, and I stress, might save you.
And we're working from a stack of sources today, primarily legal definitions from the Uniform Commercial Code, some case law summaries, and comparisons of U.S. versus U.K. consumer protection statutes.
Yeah.
So let's start with the baseline. What is the actual ironclad definition of as is?
Okay, so if we strip away all the marketing fluff and just look at the legal definition, as is a disclaimer. It indicates that the property is being sold in its existing condition without any modifications or improvements.
Okay, existing condition. That sounds straightforward enough. I'm buying the thing right in front of me.
Right. But here is where the legal weight comes in. It's not just a description of the object's physical state, it's a waiver. In legal, business, and consumer settings, this term is used to establish that the buyer is accepting the property with absolutely no warranties or guarantees.
And that's the kicker. No warranties.
None. Zero.
But why? I mean, obviously, it protects the seller, but what specifically are they trying to avoid? Because usually when I buy something, there's an expectation that it works.
You've just hit on the core concept here. They're using as is to disclaim what we call implied warranties. This is crucial to grasp.
Yeah.
When you buy something in a normal retail environment, say a toaster from a department store, there is an implied warranty of merchantability.
Merchantability, that's a $5 word.
It's a foundational legal standard. It basically means the toaster is fit for the ordinary purpose for which toasters are used. You know, it toasts the bread.
It doesn't explode. It doesn't just sit there like a paperweight.
Exactly. That is the legal safety net. But as is the specific legal incantation that cuts that safety net. It negates the implied warranty. The seller is telling you, I am not promising this thing works. I am not promising it's safe.
So if I buy that toaster as is and it doesn't toast, I essentially bought a really expensive paperweight. And the law says, congratulations on your new paperweight.
That's it. The seller is washing their hands of the item the second you hand over the cash.
And looking at our source material, there's a phrase that often goes with as is that I find even more chilling. It's the with all faults clause.
Yes, that's the standard pairing. The contract will usually say, the buyer accepts the item as is and with all faults, whether or not immediately apparent.
Whether or not immediately apparent, that's the part that gets me. It's one thing if I see a dent in the fender, I can see that fault, I accept it, but this language covers things I can't see.
Correct, and this connects us directly to the ancient legal concept of caveat emptor.
Buyer beware.
Buyer beware. But in modern law, as is kind of the weaponization of caveat emptor. When as is in play, the burden of quality shifts entirely.
How so?
In a normal transaction, the seller carries the burden to deliver a working product. In an as-is transaction, the burden is 100% on you, the buyer, to inspect the item, to get expert advice before you sign.
So once the ink is dry, the faults, hidden or visible, are yours.
They're your problem now.
And this isn't just some, handshake agreement rule. This is codified, right? We're not just talking about common law tradition here.
No, this is statutory. In the United States specifically, the Uniform Commercial Code, the UCC, it explicitly cites as is as the specific language capable of excluding implied warranties. It's written into the bedrock of commercial law.
Okay, so that's the abstract legal theory. But yeah, I want to make this real for everyone listening, because we have a scenario in the source material that is it's a nightmare. The classic used car scenario.
It's a classic for a reason. This happens every single day.
So picture this. You're at an auction, maybe a used car lot. You see a car. It looks decent. The paint is shiny. The interior smells okay. The price is right. But the contract says The buyer accepts the automobile as is, with all faults.
You sign, you pay, you get the keys, you feel great.
You feel great, and then you drive off the lot. And according to our source, literally 2 minutes later, 2 minutes, the car stalls at the first stoplight. The engine just seizes up. It's dead. A brick on wheels. It's a disaster. So naturally, you march back to the seller. You've only been gone 2 minutes. You demand a refund. What happens?
The seller points to the contract. And legally, you are out of luck.
Even though it was 2 minutes.
The timing is completely irrelevant. The severity of the failure is irrelevant.
Oh, wait, what about lemon laws? I think most listeners assume there's some sort of cooling off period for something this bad.
And that is such a dangerous assumption. Lemon laws typically apply to new cars, or they have really specific mileage and age limits that used cars often exceed. If you signed an as-is contract, you agreed to buy the car in whatever condition it presently existed.
So if that condition was about to explode, then I bought a car that was about to explode.
You accepted all faults. The seized engine is a fault. You own it.
That just feels incredibly unfair.
It feels unfair, but the law prioritizes the freedom of contract here. You were free to walk away. You were free to bring a mechanic. You didn't. You took the risk for that lower price.
I want you, the listener, to just sit with that for a second. Imagine that feeling of helplessness. You're on the side of the road, smoke pouring from the hood. You're out thousands of dollars, and the law is essentially shrugging its shoulders at you. That's the power of these two words.
It really emphasizes why the inspection phase is just non-negotiable. If you skip the mechanic, you are volunteering to take on that risk.
Okay, so if the as-is clause is the villain of this story, is there a hero? Is there any kryptonite for this clause? Because our source does mention a loophole.
There is a loophole, and this is where the nuance of the law gets fascinating.
Here's where it gets really interesting. Because while as-is protects the seller from implied warranties, it does not protect them from lying.
Precisely. We need to distinguish between implied warranties and express warranties.
Okay, break that down for us, because warranty just sounds like guarantee to most people.
So, like we said, an implied warranty is that automatic assumption that a thing works. As is kills that. An express warranty, though, is a specific promise or description made by the seller about the product. And as is generally does not kill an express warranty.
Okay, so how is an express warranty created? Do I need some certificate with a gold seal?
No, and that's the trap for the seller. An express warranty can be created simply by the seller's description of the item.
The description itself?
Yes, let's go back to that car. The seller sells it as is, but let's say in the listing, the seller explicitly described the car as having a brand new transmission.
Okay, so they made a specific factual claim, put it in writing in the ad.
Right. Now, you buy it as is. You drive away, the transmission fails. A mechanic looks at it and says, this isn't a new transmission. This thing's the original one from 15 years ago. In that case, the as-is clause does not protect the seller. The car did not conform to the seller's description. You can void the sale.
Because they made an express warranty, it has a new transmission.
Yeah.
And that turned out to be false.
Exactly. The as-is covers the condition, but it doesn't cover false descriptions. You can't sell a red car as is and deliver a blue car. The description creates a baseline that has to be met.
What if they just say, it runs great? Is that an express warranty?
That gets tricky. That's often considered puffery, just sales talk. Courts give sellers some leeway to brag, but specific, measurable claims, new tires, low mileage, rebuilt engine, accident-free, those create express warranties.
So runs great is an opinion, but new tires is a fact.
Exactly. And facts have to be true.
And this leads us to the other big exception mentioned in the source, fraud.
Yes, fraud in the inducement. This overrides everything.
Fraud in the inducement. Sounds like a crime thriller title.
It sounds dramatic, but it's very practical. It means the seller actively hid something or lied to get your signature.
Okay, give me an example of what that looks like. Not just a mistake, but actual fraud.
Okay, imagine the seller knew the engine block was cracked, and they filled it with heavy grease or even sawdust, which is an old trick to keep it quiet just long enough for you to test drive it.
Sawdust in the engine.
Yeah, it thickens the oil and quiets the knocking. It'll work for about 20 miles. That is active concealment. That is fraud.
And fraud trumps as is.
Always. It simply does not matter what disclaimers are in the contract. If the contract was signed based on a lie, if it's void for fraud, the whole thing just falls apart.
That's a relief. So there is a limit. You can't just be a total scam artist and hide behind as
Yeah,
in.
you can't. But And this is a big, but proving fraud is difficult. You have to prove they knew. You have to prove intent. It's why relying on the express warranty on the description is often a better path for a buyer.
Right. It's easier to prove the tires aren't new than to prove what was in the seller's head.
Precisely.
Now, let's raise the stakes. A bad used car might cost you $5,000, maybe $10,000, but people sign as-is contracts for something much, much bigger.
Real estate.
The real estate minefield. The source material makes a point here that I hadn't really considered. When we think of a fixer-upper house sold as is, we usually think about the physical structure.
The leaky roof, termites, foundation cracks.
Right. We think, okay, I'll hire an inspector, we'll check the beams, and if the house is standing, I'm good. But the source here says the real danger in an as-is real estate deal isn't always the bricks and mortar, it's the paperwork.
That is often where the catastrophic risks hide. When you buy a property as is, you are often agreeing to take the title and the legal standing of the property with all faults as well.
What does that look like in practice? How can paperwork be broken?
It looks like liens. It looks like unpaid public utility fees.
Liens, just to clarify, that's a debt attached to the house, right?
Yes. And this is a concept that trips people up. In real estate, debt can attach to the property itself, not just the person who owns it. So let's say the previous owner didn't pay a contractor for a renovation 5 years ago. That contractor put a lien on the house.
And if I buy the house as is,
If the deed is conveyed with an as-is clause regarding the title, and you didn't do your homework, you inherit those debts. You are now the proud owner of a house and the proud owner of the previous guy's unpaid bills.
that is brutal. So I could buy a house for $100,000 as is and find out it owes $50,000 to the city.
Theoretically, yes. And the source notes that searching public records is often really difficult. It's not like looking at a car engine. And sellers often do these searches lazily. They might say, well, I don't know of any problems. If you accept that and sign as is, you are the one left holding the bag.
So while you can inspect a physical structure with a flashlight and a ladder, these legal faults are invisible unless you're digging through municipal records.
Correct. The as-is deed burdens you, the buyer, with the mess. It's a powerful reminder that condition means more than just physical condition. It means legal condition.
It seems like the common thread here is that as is basically a request for the buyer to do all the work.
That's exactly what it is.
Okay, so we've established that in the U.S., as is a powerful weapon for sellers. But is this true everywhere? I mean, if our listeners tuning in from London or Manchester, are they facing the same 2-minute engine seizure nightmare?
This is where geography becomes destiny. And the answer is no. The U.S. approach is actually quite distinct from, say, the United Kingdom.
So how does the U.K. handle it?
The U.K. has a much more robust framework for consumer protection that limits this kind of blanket disclaimer. They have laws like the Unfair Terms in Consumer Contracts Regulations 1999 and the Sale of Goods Act 1979.
And what do those laws say about as is?
Essentially, in many jurisdictions like the UK, disclaiming implied warranties is just void, specifically for consumer transactions.
Wait, so you can't even do it?
You can't just contract your way out of selling a working product to a consumer. The law there says a product must be fit for purpose and of satisfactory quality. You can't just use the words as is to exclude liability for damage or poor quality in the same sweeping way you can in the U.S.
That's a massive difference. In the U.S., the contract is king. In the UK, the consumer protection laws can override the contract.
To an extent, yes. It reflects a different philosophy. The U.S. system leans heavily on the freedom of contract, even if that means you are free to make a terrible deal. The UK system leans more on ensuring the consumer isn't taken advantage of.
You mentioned the U.S. courts wrestling with this.
Yeah.
Is there a case that shows how hard the U.S. leans into this contract is king idea?
There's a famous case mentioned in our notes, Lenawee County Board of Health v. Messerly. It's pivotal.
Okay, walk us through it. What happened?
So the Messerleys bought an apartment building, investment property. They bought it as is. But shortly after buying it, the Board of Health condemned the property.
Why?
Turns out the septic tank system was illegal and, because of the land, essentially impossible to fix. You couldn't legally inhabit the building.
So they bought a rental property that they were legally forbidden from renting.
Exactly. The property was worthless. It had a negative value. So the Messerleys tried to sue to rescind the contract. Their argument was mutual mistake.
Mutual mistake.
Yeah, they argued that neither they nor the seller knew how bad the septic tank was. They said, we both thought we were dealing with a valuable building. Since we were both wrong, the contract should be void.
That seems reasonable. If nobody knew, it's an honest mistake.
That's what they thought. But the court ruled against them.
Really?
The court said because they signed an as-is clause, the risk of unknown defects, even defects that made the property totally useless, was assigned to the buyer. The court basically said you accepted the risk that the property might be worthless when you signed those words.
So even if the mistake ruins the value entirely, as is, sticks.
In the U.S., yes. That case is taught in law school to show just how powerful that risk allocation is. It didn't matter that it was a mistake. The contract assigned the risk of mistake to the buyer.
That is a sobering story. It really highlights how careful you have to be depending on where you were standing when you signed the paper.
Absolutely.
So what does this all mean for us? For you, the listener, we've looked at the car, the house, the law, and the map.
I think we can synthesize this into a clear reality check. As is a request. It is a request from the seller for you, the buyer, to take on all of the risk in exchange for the item.
And usually in exchange for a lower price.
Right. That's the trade-off. You get a deal, but you become the insurer. You become the warranty provider.
So the practical takeaway here is simple. Due diligence isn't just a nice to have.
No. When you see as is, due diligence is your only protection. You cannot rely on the law to save you after the signature. You have to inspect. You have to read the description and compare it to reality. You have to check the public records for loons. You have to be paranoid.
Paranoia is good. Paranoia saves you money.
In this context, absolutely.
It's fascinating because it forces us to really look at the mechanics of how we buy and sell.
It raises a provocative question about the market, doesn't it? I mean, we have to ask ourselves, does this buyer beware approach actually keep the market efficient? Well, if sellers were responsible for everything forever, if you could return a used car 5 years later because it broke, would anyone ever sell a used car? Or would the prices be so high to cover that risk that nobody could afford them?
That's the tension. Efficiency versus protection. And right now, the as-is sticker puts the weight of that tension squarely on your shoulders.
It does. It keeps the gears of commerce moving, but sometimes it grinds the individual buyer up in the process.
So the next time you see those two little words on a contract or a car window, don't just gloss over them. Treat them like a stop sign. Stop. Look. And for the love of everything, check the engine.
And the public records.
And the public records. That's it for this deep dive. Read the fine print, everyone.
Always.
We'll see you next time.